A licensee working as a residential resale agent will often make the transition to listing or renting residential property. Many vows that they will not do rentals, but with the market shift as described in Section 1, it is becoming more difficult to avoid working this market. Making the transition from selling to renting properties is a natural segue and is not considered working outside one's area of expertise or competence. Most MLS associations in Arizona share the listing between sales and rentals. Any broker focusing on residential resales could allow their licensees to do rentals, but does have the right to prevent the firm's licensees from conducting rental business. This is a business decision for any designated broker. So, what is the role of the listing agent when the owner wants to rent the property? It should be treated like any other listing regarding the forms and policies. There are a few other considerations that the broker and agent must consider. Will they use an industry standard form, such as the Arizona Association of Realtors Residential Rental Agreement? Or will the broker develop and use their own rental form? The next decision should be how the money will be handled. At different times throughout a rental transaction, a broker might ask a prospective tenant to provide money. A broker must decide how to handle any application fee or credit report fee. Any deposit is required to hold the unit and bind the lease. Move-in funds, which are the balance due to move in as shown on the lease. The broker could require that all the funds be payable to the broker's trust account, provided the broker has and maintains a trust account. To do rental listings, the broker is not obligated to open and maintain a trust account. Yet if the firm does not have one, the broker cannot accept any client funds, such as the funds described above. Without a trust account, the broker could ask that the application and/or credit fee is payable to the broker. Since those are fees, they are not refundable and thus are not client funds. The balance, including the deposit and the move-in funds, would be made payable to the owner of the property, and the lease executed between the parties should clearly reflect that fact. Without a trust account, the broker cannot accept and hold any client funds in the broker's general checking account, the same account the broker uses to pay bills, salaries, etc. Let's look at the entire rental listing process. The agent receives a call from a past client who owns the Arizona house they are living in. They have decided to move back to Florida, so they want to keep this house and turn it into a rental property. They ask the agent to list the house for rent. The agent visits the property, takes photos, and assesses what the owner would need to do in order to show it for rent. The agent recommends that the owner paint one room, shampoo the rugs, clean the windows, and trim some bushes. The owner pays for all the repairs and improvements and does not involve the agent in this process. The property goes on the market. The broker has decided that since he has a trust account, he will deposit all client monies into the broker's trust account. A prospective tenant comes forward, completes an application, and provides a credit report. The agent delivers those documents to the landlord and does not comment on the tenant's ability to perform. The agent does not review the credit report or the application, nor does the agent make any recommendations as to the creditworthiness of the tenant. Note: a property manager could perform those activities and even make the decision, but this agent is not a property manager. We should review the agent's role in the credit report and how far the agent can go in reviewing the information. Under the Fair Credit Reporting Act, which is federal law as of October 1970, only the provider of credit or financing may review and comment on the consumer's credit information. Essentially, the law states that while the landlord may review the credit information, since the landlord is the provider of credit, the listing agent may not view the credit report. The Federal Trade Commission, FTC, monitors and enforces the law, and brokers and agents need to follow the law at any time they are handling such information from a client. As a property manager, however, the agent may review the credit report since the owner empowers the agent to act on their behalf. The landlord accepts the application, approves the credit, and a lease is executed. The agent submits the lease to the landlord and deposits the checks with the broker. None of these activities constitutes property management. The day the lease is set to begin, the agent meets the tenant and the other agent at the property. They do a walkthrough, so the landlord and tenant have a clear understanding of the pre-existing conditions. The walkthrough should clearly identify if the items will stay the same or if the landlord will remedy. Once the parties finish the walkthrough, the tenant provides a check for the balance of the funds due on the lease, and the listing agent provides all the keys to the tenant. The listing agent leaves with the checks, the walkthrough punch list, and heads back to her office. She deposits the checks with the broker, copies the walkthrough report, and sends a copy to the tenant, the other agent, and the landlord. A few days later, the broker gives the agent the check for the landlord. The agent mails it to the owner, and the same day she receives her commission check. 5 weeks after the tenant moves in, the agent receives a call from the tenant telling her that the hot water tank is leaking. The agent tells them to be patient and calls the owner in Florida. The owner asks her to find a plumber to take care of the issue. She calls one that she has used in the past, and the plumber goes to the property and replaces the hot water heater. The plumber calls the agent with the invoice for payment, so the agent tells the plumber to call the owner in Florida. The plumber invoices the owner, who then pays the plumber. Is there any problem in the above scenario? Everything the agent did before the hot water heater leaked was part of the listing process and did not qualify as property management. Once the key for money exchange occurred and the agent got into her car, her role as the listing agent ended. Certainly she had some other obligations, such as depositing the check, setting up the file, and sending the landlord his money. It was the phone call from the tenant that thrust the agent into property management, all done without a property management agreement. Activity: property management, taking the listing for the lease, no receiving a rental application and running a credit report, no submitting the application and credit report to the landlord, no receiving the tenant's deposit check payable to the broker, no depositing the tenant's check to the trust account upon approval, no meeting the tenant at the property the day of move-in, no exchanging the keys for money with the tenant, no writing a walkthrough punch list with the tenant, no depositing the remaining funds to the broker's trust account, no mailing the landlord's money to the landlord. 7 days later, no. 5 weeks later, I took a call from the tenant about the hot water heater, called the landlord, and arranged for a plumber, yes. Again, the agent's role as listing agent ends when the keys for money exchange occurs, and the agent gets into her car and drives away. From that point forward, without a written property management agreement, the agent should not interact with the tenant or with the landlord about the property, its condition, repairs, concerns, complaints, etc. If the tenant calls, the agent should immediately tell them they are not managing the property and refer them to the landlord. No matter how much the tenant complains that the landlord is ignoring their calls, the agent must avoid getting involved if the licensee and the owner have not executed a property management agreement. Real estate agents, by their very nature, want to help people. Even though the agent has completed the leasing process, the call from the tenant prompts the desire to help. The owners are in Florida and have no access to plumbers or other vendors in our market. While there appears to be no harm in the agent jumping in and helping, there is a statutory and regulatory requirement for a written agreement before an agent or broker can legally provide property management services. Section 3 will explore the property management agreement, what it must contain, what it may contain, and the process for canceling the agreement. What could or should the agent do when she receives a call from the tenant 5 weeks after the tenant receives the keys to the property? The agent should tell the tenant that she is not the manager and cannot assist. Any calls or communication must be between the landlord and the tenant. A broker that does not allow property management in their firm should supervise their agents and instruct them on how far they can cross the line into property management. Since property management carries inherent risk, properly executing property management with a required management agreement, diligent accounting in the trust account, and handling tenant and landlord issues is challenging and risky enough. Doing property management without realizing that your firm is involved in this activity and without the correct agreements and with poor accounting procedures will almost certainly result in complications and complaints filed with ADRA.